Imagine this. Your parent has passed away. You just learned there's a trust. Maybe you've been disinherited. Maybe your inheritance was reduced. Or maybe the trustee won't answer your questions or provide you with a copy of the trust. You believe something isn't right, and you've decided you need the probate court to get involved. So, where do you begin? In many California probate disputes, the answer begins with a petition. But what exactly is a petition? Hi, my name is Angelique. I'm an educator, not an attorney. I created this channel to help self represented litigants better understand the California probate process. The information in this video is for educational purposes only and should not be considered legal advice. When my siblings and I first started looking into our case, my sister told me that if we wanted to file a case, we need to file a petition. That was about all we knew. We didn't know what a petition was, how to write one, or even where to file it. However, it was enough to point us in the right direction. At the time, I thought writing a petition was just filling out a form. I learned that it was much more than that. I had to actually write one. A petition is a formal written request asking the probate court to make a decision. It isn't just your side of the story. It's your opportunity to explain what happened, how the laws apply to your situation, and what you're asking the court to do. As an educator, I spent years teaching university students how to write scientific research papers. I have found that complex topics become much easier to understand when you break them down into smaller pieces. So, if I were teaching this to my students, I'd break a petition down into three broad categories. One, the technical requirements, how the petition should look on the outside. Two, the legal content, what goes inside the petition. And three, the procedural steps, what to do with the petition once you finish writing it. Thinking about it this way made the process feel much less overwhelming. Let's take a closer look at each one. The first category is technical requirements. I think of this as how the petition should look on the outside. Before the court considers what's written in your petition, the document itself needs to follow the court's formatting requirements. This includes things like pleading paper, the cover page, the required font and spacing, page numbering, headings, titles, signatures, and other formatting requirements the court expects. These details don't tell your story, but they're important. If your petition doesn't meet the court's requirements, it may be rejected or returned to you for corrections before your case can move forward. The second category is legal content. I think of this as what goes inside the petition. This is the substance of your petition. It includes the facts of your case, the legal basis for your claims, and the relief you're asking the court to grant. More specifically, you're answering questions like, who are the parties involved? What happened? Why are you asking the court to get involved? What law supports your request? And what do you want the judge to do? A petition isn't just about telling the court what happened. It's about showing why the law supports what you're asking the court to do. The third category is procedural steps. I think of this as what to do with the petition once you've finished writing it. Writing the petition is only part of the process. Once it's complete, you'll need to file it with the court, pay the filing fee, or request a filing waiver if you qualify, receive a hearing date, and serve the required notices on the people involved. These procedural steps are just as important as the petition itself. If one of those steps is missed or done incorrectly, it can delay your case or create additional problems that you'll need to fix before moving forward. Writing a petition can feel overwhelming because most people don't know where to begin. What helped me was breaking the petition down into three categories and focusing on one part at a time instead of trying to do everything at once. For example, I'd work on the legal content. Then I'd switch it over and make sure the formatting looked right. Sometimes while I'm formatting, I'd realize I had left something out, so I'd go back and revise the content. Once I was satisfied with the petition itself, I could focus on filing it and serving the required notices. Breaking it down that way made the entire process feel much less overwhelming. I hope this framework helps you better understand what a petition is and how all the pieces fit together. If you found this video helpful, I'd appreciate if you subscribe to the channel. And if you'd like to see where filing a petition fits into the overall probate litigation process, I've linked my California probate litigation roadmap at the end of this video. Thanks for watching, and I'll see you next time.